Good morning all, and welcome to the first session done remotely from home. The aim of this morning's session is to have a look at the next topic in the law of tort, and that is occupier's liability. I'm just going to take you quickly through the slides which I'm going to put on Microsoft Teams. Let's make a quick start. So on the first slide you would identify, it clearly says occupier's liability what? That simply relates to the responsibility that an occupier of land or premises has when they have other people coming onto the land. The main focus for this lesson will be based on the Occupiers Liability Act 1957, which only relates to lawful visitors. Right, just going to move on to the next slide. So the main legal authority that deals with occupiers' responsibility for people who visit their land is the Occupiers Liability Act 1957. There is two different types of acts. The earlier one, which is the 1957 Act, deals with lawful visitors. So under section 1, subsection 1 of the Occupiers Liability Act 1957, it simply relates to the common law authority on occupiers' liability is now enshrined in an Act of Parliament, and that Act is the Occupiers Liability Act 1957. So that's the provision under section 1, subsection 1. Right, next slide is to do with who is an occupier. So in other words, who is a potential defendant because they've fallen below the standard of that required of a reasonable occupier. So occupier has no statutory definition. The actual definition for the word occupier or owner of land or building or car can be found in cases. So there's a case to emphasise that, and we'll have a quick look at the case. If you go to the next slide, we have the case of Wheat and E. Laken to do with a manager who wasn't actually the owner of land, but he was certainly a tenant and manager of premises, and he rented property out to another person. They got injured. And the courts clearly emphasise that an occupier can be the owner of land or anybody in control of land. So that's important that when you read through the notes and you look through the slides, then the case of Wheat and E. Laken is mainly to do with who an occupier is, and that can be owner of land or anybody in control of it. Next slide is to do with Harris and Birkenhead. Again, you've got somebody injured in that particular case. Have a quick read of that. Can the owner be responsible for those injuries? It depends on whether the provisions of the 57 Act are fully met, but I'll leave you to have a quick read of that. Sorry about going in and out, but I'm just trying to follow the slide so you can actually use this clip to help you understand the slides. Now the next case is Bailey and Ames or Arms in 1999, and that case is all about where the court struggled to identify who the defendant was. In other words, who was the owner of land, and it's to do with where children went through a window and then fell and injured themselves. And the key point here is, can somebody be in charge of access to a roof? In other words, can somebody be in charge of just a window? And the court seemed to think that that would be very difficult to confirm, and therefore in this particular case the owner couldn't be identified, and therefore the claimant would leave with no remedy, which is in a way a bit of a sad case. Right, now we're looking at we've moved away from what or who an occupier is, and that's somebody who owns land or somebody who is in control of land. We're now moving to the next word, which is premises. So when we talk about premises, what do we mean? The key point to appreciate here again is that there's no statutory definition. Section 1 subsection 3 of the Occupiers Liability Act 1957 simply gives you examples of what may class as premises, but in our everyday life we can suggest very easily that premises would involve a house or any type of building, a vessel, a caravan, a car, and even if you could extend that further to include a ladder. So the word premises can be wide and varied, but it's very important that you identify who the occupier is, because they are potential defendants, and then you also identify what premises is. So if those two things are present, then it's very likely that any injury sustained by the claimant may be the responsibility of the occupier. Right, very quickly then, there is an exception to when an owner would be responsible under the Occupiers Liability Act 1957. So if you have a look at the case of Revel and Newbury 1996, it's on the slides that I've given you. The courts, even though the defendant waited, because he'd been burgled in the past, waited in a shed and then shot a gun at the claimant, and the claimant was injured, the court suggested that the Occupiers Liability Act wouldn't be appropriate in this instance, because you're looking at a one-off incident. Now, if the danger was continuous, such as a massive hole in the ground which was there permanently, and someone falls and hurts themselves, then the danger is continuous, and the owner is under a duty to keep it safe. So in Revel and Newbury, the key point is, even though the claimant was injured, they wouldn't have a remedy under the Occupiers Liability Act 1957. They would have to sue in negligence. As an examination tip, please remember that the Occupiers Liability Act is very similar to negligence claims, and therefore it would require a student to read very carefully the question and identify which action to pursue or discuss. So are you going to talk about negligence, or are you going to talk about occupiers liability? I think it's easier to sometimes spot if a case or a question falls under the Occupiers Liability Act, because there'll be a clear owner or occupier, and there'll be premises involved as well. So that might be a clue as to not pursuing negligence in your answer, but thinking about the Occupiers Liability Act 1957. Right, moving on then, the Section 2, subsection 1 of the Occupiers Liability Act 1957 is probably the most important provision, because that clearly identifies that all occupiers of premises owe a duty of care to lawful visitors. You've got typical examples of lawful visitors on the next slide, and that's to do with adult visitors, so anybody invited onto the premises. The defendant occupier has to be careful that they're not injured. Invitees, again, very similar. They could be anybody who you invite onto the premises. Licensees would be typical persons who, for example, have rented a space to keep a caravan, for example. Again, the owner of the land or the occupier must make sure that they're safe. Contractual permission is the next example, and that's simply to do with anybody who's paid to enjoy a piece of land for a period of time. So if you book a camping holiday, then by reason of the contract you have with the occupier, then you must be kept safe on the premises. And those who have a statutory right of duty will include people coming to read gas meters, or the police if they have a warrant to search premises, and so on. So they're typical examples of lawful visitors that come under the Occupiers Liability Act 1957. Right, move on to the next point. Section 2, subsection 2 of the Occupiers Liability Act 1957 relates to the responsibility of occupiers to keep their premises not completely safe, but reasonably safe. The next cases confirm that. So if you have a look at Laverton and Kaya Pasha, to do with where somebody slipped in a Chinese shop, a Chinese takeaway shop, the question is, would the occupiers be responsible? And the court said, well, they'd fitted non-slip tile, so that clearly indicates that they were trying to minimise the risk of slips and falls to any persons who visited the premises. So the property would be classed as reasonably safe, and therefore no action under the Occupiers Liability Act 1957. Right, Dean and Chapter of Rochester and DeBell in 2006, again, have a look at that. It confirms that if property is or premises is reasonably safe, then there's no claim if somebody does get injured. Okay, now one point to note is the fact that you might start off as a lawful visitor. So if I invite you into my house for a party, then you're classed as a lawful visitor. However, if you go beyond the permission to visit my house and you sort of wander into my bedroom and take anything from my property and slip down the stairs and hurt yourself, then you become a trespasser because you've exceeded your invitation in terms of the right to visit the premises. Right, okay. Accidents are not covered, so have a look at the case of Cole and David Gilbert. So I'll leave you to have a quick read of that. Special duty owed to children, so section 2(3)(a), and the key word that you might come across there would be the word allurement, which simply means anything that attracts children to that particular item. So it might be on a council park, for example. There might be a broken down car or a disused car. Naturally, children wandering around the park would be tempted to have a little play in the car, and if they hurt themselves, then it's likely that they will be able to claim compensation because the broken down car acts as an allurement. So the case that confirms that is Glasgow Corporation and Taylor, 1922. I shall leave you to have a read of that, and I shall leave you to identify what the allurement was, and also for you to identify whether the claimant was able to successfully make a claim. Phipps and Rochester, again, have a look at that case. The key thing from that particular case is to do with the fact that slightly older children, so 7 years, maybe 5 years even, will struggle to make a claim because the idea is that the parents of the children would be looking after them. So I think that's a clear difference here. If you're slightly older, then it would be difficult for you to claim because it's anticipated that you'll be under the supervision of your own parents. So do bear that in mind. Jolly and London Borough of Sutton, a very important case where the court of first instance, the High Court, allowed a claim when the claimants were injured, being attracted to an allurement, broken down canoe, I believe it was. And then the Court of Appeal overruled the High Court and said they couldn't claim, and then it went to the House of Lords, as it was then. It's now the Supreme Court, and they agreed that a claim could be made. The general point from Jolly and London Borough of Sutton is the fact that any injuries sustained by the claimant have to be reasonably foreseeable. If they're not, then it's going to be difficult to claim. But in this particular case, even though the decisions or verdicts went to and fro, it did end up with the court, with the House of Lords agreeing that a claim could be made because the children were naturally attracted to the allurement in this particular case. Right, and the next case, nearly at the end of part one, it's to do with liability owed to persons carrying out a trade or business. The general idea is that occupiers or owners of premises would owe a slightly less duty of care to such persons. Mainly because if you're a professional, then it's assumed that you'll be able to take reasonable steps to be safe on somebody else's premises. Rolls and Nathan in 1963, to do with carbon monoxide, do have a look at that case and decide whether they could claim or not based on the fact that they were professionals. And I believe that is a quick run through the first part of Occupier's Liability. So this particular lecture only focuses on the 1957 Act. Lawful visitors, the keywords to remember are occupier and premises, and section 2(1), which clearly states the duty imposed on the defendant to keep people safe on premises. And also obviously section 1(3) is to do with examples of premises. Do remember also, as a quick summary, that the word occupier or owner of land is not defined in any statute. However, we go to cases, and the same applies to premises, not defined in any statute. Again, cases do clarify what premises are. Right, okay, thank you so much for listening to this quick video clip. Any questions you may have, I shall be in front of my computer, so through chat or email, ask me any questions. And I think the key point here is, after you've read the reading in the textbook and you've gone through the slides and watched this little clip, then please make sure that you carry out the individual class exercise, which is simply to summarize what your understanding of the occupier's liability at 1957. Right, it's 15 minutes, so I think I'm going to finish here. All the best and stay safe. Thank you.